Hi guys, it's Kathy. I hope you're doing well. Sorry I'm late. Thank you, CJ, for waking me up. This time I think you'll understand, though. I really do. I really do. So, I did my stream yesterday. Both of them for 4 hours. And then when I got off my stream, I uploaded a video real quick. And then I went into work. But then, while I was at work, I found out I had to work a double. And I got home 5 hours ago. And I was tired because it was a long day. And that was 5 hours ago. So I did miss my alarm clock again. I bought a new alarm yesterday for it, so it's just sitting there not waking me up. But it's okay because I have batteries coming today, I hope. Martha, I just walked. I worked a double, and I just walked to the chair this morning like I was 18. My ankles and my feet are perfect. Martha, thank you. Martha, thank you. I don't even know how else to say it. Martha, thank you so much. I just walked to the chair. I didn't even notice it till I sat down. And then I was like, what? I just walked over here. Normally it hurts. And I'm like, oh. Alright. Now, Josh saved us a bit today because I actually only had time to find one clip. I got off work 5 hours ago. I found one clip and then I accidentally fell asleep. But Josh sent me a link, so he saved the rest of the stream today. However, the one clip that I did find, Bobby, get ready, okay? It does have some vulgar language, explicit language in it. I was in the mood to get another attorney disbarred when I got off work last night. I was like, okay, I need an attorney that was disbarred. That's what I need right now. So we're gonna watch an appeals case of an attorney that was disbarred. And when they talk about the law and some of the things that he did, that he didn't do this stuff, but some of the things that apply to that law, they use very strong language that really might offend some people today. Today you might be offended. I'm telling you that now because if you think that you could be offended, today is the day, so go do something else for the next 36 minutes and 5 seconds after I press play. Because if you can be offended, today is the day you're going to be offended by some of the words that come out of the attorney's mouth. Nan won't be offended. Not by that, I don't think. I don't think Nan will be offended. And then Josh will save the rest of the stream. Easily. What I'm hoping for is while you guys are watching this 36 minutes and 5 seconds, I can find out the answer if the attorney is actually still disbarred. Before this clip, the attorney was disbarred. They are taking it to the Iowa Appeals Court. So that's what we're going to watch. We're going to watch an appeal happen. But I don't know the answer to the appeal. Luckily, though, the Supreme Court of States usually post their decisions. And this was 1 year ago. And I have I have a sweet, nice little case number, which means I don't have to go looking for it. The case number's there. So, I don't remember setting this up. And I did set this up. Oh man. Ha. I don't know, Malta. You won't have to listen. You will not have to listen intently. It will punch you right in the face when it starts happening. And then it happens again. As of 1/2 hour ago, everyone in California has been disbarred. Yep. I heard. I live real close to New York. But I don't go to New York often. Like, you couldn't pay me enough. They have this huge Harry Potter shop I've never even seen. And that's a big deal, because you would have thought I'd be the very first person at that door. But no, no, I don't know. I don't think I could do that. I don't think I could function in New York. So, I always tell myself I'm just going to hop on the train. I'm not going to drive to New York. It's like a 2.5 hour drive maybe. Nothing, not a big deal. But I always tell myself I'm just going to hop on a train and just get off right by there's a station right by the Harry Potter shop, I think. Oh God. What is that station called, guys? The real big one. Nope. Grand Central Station. I could just hop off at Grand Central Station and then go see the Harry Potter shop. But no, I don't think I could do it. Nope. I would be in big trouble. I would be lost in the city. I'm very bad at directions. I would be lost wandering around New York and you wouldn't see me for 5 years. Hopefully. But let's go to Iowa. We never get to see Iowa. So this is a big deal. We get to hear their accent. They don't have an accent. Where's the button? Here we go.
The court will now hear argument in Iowa Supreme Court Attorney Discipline Board versus Ruben Andrew Neff. Mr. Cease.
Court. As mentioned, my name is Matthew Cease, and I represent Ruben Neff in this matter. Today, we ask that this court reverse the findings of the Grievance Commission in that Mr. Neff violated Iowa Rule of Professional Conduct 32.8.4 sub G. We ask this for 2 reasons. First, we ask that this court find that none of the conduct that Mr. Neff engaged in constituted sexual harassment under Rule 32.8.4 sub G. And secondly, alternatively, we ask that this court find that Mr. Neff's protected by the First Amendment as it relates to the conduct that happened in this case.
Watkins to find that this was not sexual harassment within the meaning of the rule?
Outright overrule Watkins. I think that you can modify Watkins, and the biggest problem that I see and the potential conflict with Watkins in the reading of the rule is the expansion of the definition of sexual harassment to include gender harassment. And I think what's happening in Watkins and the interpretation that led to the prosecution of Mr. Neff in this case results in that we're starting to blend sexual harassment with gender discrimination. And if it's gender discrimination, then it would have to fit under the second provision of 32.8.4 sub G, which says that it's other unlawful conduct. And if it's unlawful conduct, his actions or any attorney's actions have to be in violation of some law. So it has to be unlawful. So it has to be in violation of Title VII or the Iowa Civil Rights Act or some other anti-discriminatory actions.
To redefine sexual harassment, I think as we define it in Stansberry, physical or verbal act of a sexual nature that has no legitimate place in a legal setting. Is that still a good definition?
Actual definition, the first definition of sexual harassment came from Steffi's in 1999. And in Steffi's, they quoted Black's Law Dictionary, and I think it's basically the same thing, where it says there's sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. And that's what the definition was in Steffi's, and it's been adopted.
Position, I think. And let me read you from Watkins or from Steffes. It's a verbal act. So here we have words, right? So that it meets that. And it says of a sexual nature.
Hi, Violet. I'm glad you're here. Again, I'm warning people who just walked in. There's vulgar language involved here. I'm telling you, you're going to get offended.
And here he uses the F word. He makes some allegations about rape. The board says that's of a sexual nature. It seems like you're agreeing with that definition. If you are, then why isn't there a violation of the rule?
Reasons. First, Steffi's left out an important part of the Black's Law Dictionary definition. And the next words of the Black's Law definition, after other verbal or physical conduct of a sexual nature, the Black says prohibited by federal law and commonly by state statutes. And so Black's is recognizing that definition as it has to be prohibitive under federal law. And that's where Steffi's and Moothart and I believe and even Watkins recognize that, well, we can't say that it has to be in violation of Title VII. And I don't necessarily disagree with that, because Title VII is obviously limited to an employee-employer context. And I think it's fine for the court to say, we are going to govern behavior of attorneys outside of that as it relates to dealing with clients, court personnel, or people of that like, that wouldn't fit technically within Title VII. But where I have the problem, and I think that the issue arises that creates all of these other issues with the First Amendment and that is when we are saying, yeah, Title VII doesn't apply, so that means the requirements of severity and pervasiveness don't apply. That's where we run into all of the constitutional problems.
Okay, what everybody else in the room knows right now, but you don't, is, and I'm about to say some not really offensive language, but offensive language. So, Neff, the person in trouble right now, he made 9 comments on the record. He's in trouble because he made offensive comments repeatedly to his staff, about defendants, and even about judges. Okay? It was sexually charged and demeaning comments in his workplace. That's the problem. So, telling staff that a criminal defendant's asshole would be this big after time in prison with hand gestures that I'm not doing. In a sexual exploitation case, he told his staffer the defendant should lube up and grab his ankles. After losing a case, he said he wished the defendants... Okay, this is what he said, okay? He said he wished the defendants would be raped by antelopes and mauled by lions. He called judges bitches and once called one limp dick. He repeated a slur, faggot, to a staff member who identifies as LGBTQ after being told it was offensive. Some of the comments were made in front of staff. 2 employees resigned because of his conduct. And no, he was not disbarred at the time of this hearing. He was put on a 60-day suspension. Probably without pay. So, he's here appealing this 60-day suspension. All right, go.
Now, and going back to Steffi's and even in
The employment context, at least, that there should be a higher threshold. And maybe it's not jot for jot the same as Title VII, but something that's approaching what would be Title VII liability.
understand your question correctly, I think that's exactly what I'm saying, is that we aren't going to say that, well, like in the context of dealing with court personnel, if an attorney is referring to that court personnel in a derogatory, sexist manner, and it's pervasive enough that it either affects that person or people around that attorney, then that would be a violation, even though it wouldn't technically be a violation of Title VII. But to go back to your original question, I don't believe that these items are sexual in nature either. And going back to Steffi's, if you look at what the reason they found, this court found a violation in Steffi's is Mr. Steffi's had taken photos that were not related to his representation, arguably. He was arguing that they were related to his representation, but they were of a female client of his in a drug case. He took photos of her back and of her front while she was not clothed. And the court in that said, we find that this is sexual harassment, and it was sexual in nature because it filtered into Steffi's prurient nature. And I think that's what the issue is, that you can still have that sexual in nature.
In Watkins, we also defined it as a put-down aimed at degrading or demeaning women. Is that no longer a good definition?
It is in the context of sexual nature. And if you look at where that language comes from in Watkins, that comes from the Fitzgerald article, which is not a, and is clear within the context of the Fitzgerald article, is not a legal treatise or was being interpreted as the law is supposed to be written. Those were psychologists and professors that said, we are doing this with a feminist viewpoint in interpreting how we believe sexual harassment is, to outline what it is. And it is broader than what the law may require. And then they specifically talked about gender harassment as a subset of sexual harassment.
And we can argue about these particular statements and what they mean. But let's just take an easy one. Let's say Watkins said, Neff said, I don't think women are competent and qualified to be judges. And let's say he said it within the confines of his office. Is that a violation of the rule?
If it's
I'm sorry, it's coming soon. There is some very strong language in this clip. This clip is 8 minutes in of a 36-minute clip. There's offensive language coming up. If you're about to be offended, go watch something else for 29 minutes. Offensive language is coming.
It's a one-off statement like that. I think it's going to run into First Amendment problems by saying that. And it gets closer. And if you look even at the article in that Fitzgerald article, they talk about if it's pervasive enough to affect individuals working and interfering with their work, then it can. But if it's a one-off statement, like you said, and it's offering his opinion to that, I don't know if it necessarily is, and I would argue that it doesn't.
A statement that is made once, but it's part of a larger context where similar statements are being made, and that's enough, isn't it? I mean, we don't just look at the sort of, well, you use this word one time. If you're sort of using similar words a multitude of times, isn't that enough?
It could, if it all lines into the context of everything, to show that these statements are being made because of the person's gender or a viewpoint that's going to affect an individual that's under a protected class. It doesn't even have to be gender, but under a protective class like a typical Title VII case would be and what it would fall under.
I'm sort of thinking out loud, and I'm just one of six of us, but let me kind of come at it a different way. I mean, what it prohibits is sexual harassment. And I'm maybe less concerned about the First Amendment part of it than maybe some of the other members of the court. But I am concerned that it has to be sexual and it has to be harassment. So that tells me kind of two things. I'm not a Title VII lawyer. I'm not an expert in that. But it says you can first of all, you can sort of say what you want if you go off on a desert island and you say it, because you're not harassing anybody. Secondly, you can say things that are, you can be a pain in the neck, but if it's not sexual in nature, then it doesn't meet the definition. So it has to meet both components. Is that too complicated or too simple a view of it?
That you're not practicing, you are on track with what Title VII courts have found, particularly the court or that the board relies on in Reeves. The Reeves case outlines a female employee that was objected to a barrage of insults, including the word bitch, that forms basis here, but it's on and it's being used in a different context, and it's pervasive. And in that case specifically, the court said, we're not going to, and Title VII is not a general civility code. And I don't think that Rule 32 8.4G should be a general civility code either. And so if the claims do not reach to the level, or they're indiscriminate, if it's an indiscriminate discussion about sex, or the use of derogatory terms or vulgar terms, it does not necessarily by itself lead to a finding of sexual harassment under Title VII.
To be sexual in nature, to be sexual harassment, correct?
Well, I think the Title VII reading of sexual harassment is the same reading as the Black's Law Dictionary definition.
Then there can be sexual harassment, hostile work environment, sexual harassment for any treatment that creates a hostile environment because of someone's sex, whether the comments are actually sexual in nature or not.
Level of pervasiveness, yes.
Like, it doesn't have to be sexual to be sexual harassment within the meaning of Title VII. I mean, it's an under-inclusion, over-inclusion problem.
I understand what you're saying, yeah.
If an employer says, we are going to unfairly treat women in our workplace for the purposes of driving them out and making it hostile, but we're not going to use any sexual statements, we're going to criticize their performance evaluations over harshly, we're going to require them to be here at odd hours of the night. We'll never give them any meaningful work. But, I mean, you get the point. So it doesn't have to be sexual in that sense to constitute harassment.
And here's where I struggle with that, is what you've just described, I believe, is sex discrimination. And it's discrimination based on that person's gender. And treating a specific class of individuals differently because of their gender.
That's facts,
and
You're
that's
right.
different than sexual harassment, which
That's true, too.
involves the physical conduct and things like that involve sex acts or the threats of sex acts or just the general discussions of sex acts in a way. And I think if you put it back into Steffi's, further the prurient viewpoint of the person that's uttering those words.
Appears in subsection G.
But it's got to be unlawful discrimination. So the conduct has to rise to the level of a violation of Title VII. And to take it back to this case, I don't think there's anybody that could argue that if this was a Title VII case, that it would survive even a motion for summary judgment, let alone be successful on the merits to determine that it is an unlawful violation. The actions in this case are not pervasive enough to get to and rise to that level.
The First Amendment.
And I see my time's about out, so I'm going to keep it brief.
And they told him, Kelly, it was offensive. They told him the words he was using was offensive. And they kept doing it.
But we rely heavily in the decision by the Idaho Supreme Court, and their striking down of Idaho's proposal of the ABA's version of
I
8.4.
didn't get my state
And
wrong.
arguably,
This is
the way that
Iowa.
Watkins is being interpreted and being used in this case, our standard is actually broader than what happened in Watkins, or what the proposed language was in Idaho that was ultimately struck down. And I think it's important to point out what the language was in that case, or what the rule was proposed. It says that harassment must be severe or pervasive enough to create an environment that is intimidating or hostile to a reasonable person. That was struck down as being in violation of the First Amendment. And that's arguably a more strict reading than what we have in this case. And in fact, I'm not certain in reading the rules that were proposed in Idaho that Mr. Neff would have even been charged if that was the standard. Because in the comments, they specifically say that you look to the frequency of the harassing conduct, its severity, whether it's threatening or humiliating, or a mere offensive utterance, whether it's harmful to another person or whether it unreasonably interferes with conduct related to that. Petty slights, annoyances, and isolated incidences, unless extremely serious, will not rise to the level of harassment under that section. Now, the Idaho Supreme Court said that that was both overly broad in its terms, and it was unconstitutionally vague. And I think if that was the situation there, we certainly reached that level in this case. I see I'm out of time. Thank you.
May it please the court, opposing counsel. My name is Rob Howard, and I represent the appellee, the Attorney Disciplinary Board. The board is asking that this court uphold the constitutionality of Iowa Rule of Professional Conduct 32 8.4G and find that Mr. Neff violated that on several occasions. The rule is constitutional as it survives strict scrutiny, is not overly broad, is not vague, is constitutional as applied to Mr. Neff. And Mr. Neff violated this because he is a lawyer who engaged in sexual harassment or other unlawful discrimination in the practice of law without a legitimate legal purpose.
Let me ask you this. Let's assume two female attorneys in this office were in the lunchroom talking about a sexual encounter one of them had over the weekend. Does that violate the rule?
In that context, I mean, I do believe that it would have to, yes, I believe it would violate the rule. The idea of women and women or same-sex violations has been dealt with by the U.S. Supreme Court in Onkale v. Sundowner Offshore Services.
Is that there was a verbal act, it involved sex, it wasn't relevant to the work topic or their workplace.
You're correct.
You think the board thinks that's harassment?
It would be, if they're in on the lunch break, is that the practice of law? That would be a fact question that we'd have to get into. Being in the practice of law.
Desks.
Some offensive language is coming, guys. If you just got here, if you can be offended today, you will be offended. Offensive language is coming right up. And my coffee's here, so enjoy it. I'll be right back.
And they're cubicle co-workers, and they're talking about a sexual encounter over the weekend. Is that sexual harassment in the board's view?
Their coworkers or with their coworkers.
They're in this county attorney's office. They're both women, and they're talking about sex unrelated to any case in the workplace.
I do believe that that would be under the Watkins definition, sexual harassment, and under Moothart, where this court has said it's a per se rule regarding sexual harassment, even if it wouldn't give rise to civil liability. It's verbal acts.
Asked in that context.
I think that is a procedural thing that may happen. Let's say that in that example, one of the females was like, I didn't want to hear that. That would be the only way that the board would actually ever hear about it. So if it occurs in a vacuum, just like some other items might occur which never are heard from, I do believe that somebody does have to feel harassed in it, but that's more of a procedure on how it would actually be move up the line rather than if it is a violation.
Doesn't matter. Justice McDonald's question is about whether or not that's a violation. Is it a violation? What, I mean, a violation happens whether somebody reports it or not, correct?
But I believe that that kind of goes to the, is it something where somebody would have to feel harassed then? There would have to have that. And I do think that there's sort of this subjective objective that would happen. So what would happen procedure-wise is,
Office of all men, and they just engage in horrible behavior, and they think it's hysterical and funny, and nobody feels harassed. Are you saying that that's okay?
that that would be clearly a violation of it. I guess, big picture,
I mean, that's the problem. Who's the harassee then?
this kind of brings us to the strict scrutiny analysis, which is what the compelling interest is here. And that is the equal and unhindered participation with the practice of law. So let's say, obviously, you know, these things happening in a hermetically sealed environment where nobody ever hears about them, then nothing ever happens. I mean, that's just a fact. However, why this rule was created was because people were hearing about it. They were hearing that that's how lawyers behaved. It was driving women out of the practice of law or engaging with the practice of law, not only from the workforce, but from engaging with the court system.
In this case?
That was one of the stipulated facts that 2 women left their employment in part because of Mr. Neff's conduct.
I mean, the notion of, like, let's say you had 2 male attorneys who you know, like one of the allegations in this case, or actually it's not an allegation, it's a stipulated fact, you know, several times used the B word to refer to a female judge, all right? So let's say that happens. It's 2 male attorneys, you know, kind of, and I understand that that language is offensive, and it can, there's an undertone that you're respecting that judge less because of the judge's gender. But if they both, you know, if neither one is harassing each other, how is that sexual harassment?
The fact that if especially from a county attorney, that his opinion of female judges, and again, I would say that the way that that was charged and brought was as a whole. He said things about a male judge, he said things about...
My hypothetical, you're not going to change it.
Yes, again, I would go back to the fact that it's how this gets out, and then we have a county attorney, and we understand that the perspective is that female judges don't make good decisions. I do think that we're not looking at who's necessarily harassed, it's sort of the legal community in general, and that's the protection, that's the compelling state interest.
That sounds like the part of the rule that this court didn't adopt, you know, the sort of expressions of bias and things like that. That sounds like an expression of bias to me, but harassment, you know, in Watkins, there were 2 people that clearly were being harassed. Here, there are 2 people that are allegedly were harassed as well, and that needs to be
I don't feel
addressed.
you're
But
safe.
it seems to me you have to have a
with your sound
harassee
on.
in order to fall under that part of the rule, right?
You'll know when it happens the first
I think
time.
that it is something more
everybody in chat
where
will
it's
say,
about how
"Oh,
it affects the legal community in
wow."
general. I think that even if there was in your example where it's a bunch of guys sitting around the law office while practicing and they're making a bunch of jokes and that gets out, that is the compelling state interest, is that people are like, ick, I don't want to deal with the legal community. And we have to make sure that we are having equal access to it. So I think that I understand that you're saying that there must be somebody who actually feels harassed. We actually do have that in this factual stipulation.
Let me phrase it this way. Let me turn your attention to the text of the rule and the words "or other." What work is that doing, specifically the word "other"?
I suppose sexual harassment or other unlawful discrimination. I think that is partly why the court did not adopt such a strict reading of sexual harassment or other. But
At least that implies to me that sexual harassment, as used in that sentence, must also be unlawful, right? Because it doesn't say sexual harassment or unlawful discrimination. It says sexual harassment or other unlawful discrimination.
Would be that it would be sexual harassment or rather than and other unlawful discrimination. So I think you'd have sexual harassment or you'd have other unlawful discrimination. I do believe that
What work does the word other do in that sentence? You could say sexual harassment or unlawful discrimination.
is what it does. It does make it a very broad, just like sexual harassment was defined broadly. Other unlawful discrimination is defined broadly. So I would disagree with Mr. Neff's position.
It's unlawful discrimination or it's not. What does other unlawful discrimination mean?
My plain reading of the text would be any other unlawful discrimination. Maybe I'm not understanding the question correctly, but I think that or very clearly separates two different items.
The natural way to read that is sexual harassment. And when you say or other unlawful discrimination, the implication is sexual harassment must also be read to be a form of unlawful discrimination, which means there has to be some sort of, approach to a Title VII threshold to get there.
Well, I do think that Mr. Neff's position is correct, where there is an approach to Title VII analysis there, and they did take our definition of verbal conduct of a sexual nature from Title VII. That's where it gets from Black's Law Dictionary. I think this court intentionally ended it there. I think the other unlawful is making it very broad for any other type of discrimination that may occur that obviously is unlawful as well.
Ambiguous. Shouldn't we construe the rule in a way that avoids a First Amendment problem? That is, by requiring the sexual harassment to be literally unlawful under Title VII or the Iowa Civil Rights Act or some other law.
I would disagree with that. So the compelling state interest here is very much different. It is making sure that everybody has equal and unhindered access to the practice of law. So because we're not talking about just an employment context, and this comes out in mistaken. And I think the homosexual slur, that's pretty severe. I think the comments about the criminal defendants wishing sodomy and bestiality and painting a fairly pornographic picture for his employees, that's pretty severe.
Sexual? He says he wants this guy to be mauled by lions and rape. I don't see how that's sexual. I mean, it seems silly, stupid. It seems like that's a really overly literal reading of this to say that, I don't know.
Judge, those things were
The
very
factual matter,
sexual.
I have a very difficult
just
time
are.
finding that to be sexual.
Oof.
Problem
It's
that he
very-
wished the criminal defendants would be mauled by lions, at least under this. It's that they were sodomized. That's the board's issue, is that he wished sodomy upon them in very graphic detail.
Legislature agreed that this is a really important issue about making the profession free of sexual harassment. And they passed a statute that codified our rule and criminalized it. If Mr. Neff had said, for example, this judge is a limp dick, would it violate the First Amendment to send him to jail for saying that?
Actually, the way that this was brought, I would say no. Just a one-off comment in that instance may not violate this. It's what we were able to glean, and this was the way that the board brought it, from limp dick and bitches. We were able to glean what his perspective was on sort of gender stereotyping. So I think there was a pervasive element here that existed, though not necessary under this court, as this court has previously defined, but I think there was a pervasive element. And that's something that we have severity on one hand with a couple of his comments, we have pervasiveness with his other comments, and there were multiple comments here. I think that this ultimately
Necessary. So you think that he could, for example, commit a criminal offense by calling judges bitches And that would be square with the First Amendment.
I believe that it would be the same, it would be
Oh,
it
I'm a
would be
criminal,
square with the
guys.
First Amendment as any harassment is.
I am
But
a
the reason why it's
criminal.
square with the First Amendment in this case and in other harassment cases is that legitimate legal.
One sentence, and you keep saying that would be okay if it was pervasive. And I think that's right. I mean, that's why we have Title VII, and there's this threshold of pervasiveness that actually alters somebody's condition of employment. I'm asking you to survive constitutional scrutiny, is that pervasiveness requirement necessary? And if not, can he go to jail for saying a judge is a limp dick? One time.
I'm sorry. Yes, it would be as any other harassment, State v. Frodsky, State v. Baker, any other harassment. I'm assuming if it was criminal, that's what it would be. However, like those criminal statutes against harassment, this would have the constitutional safety valve of saying, did he have a legitimate legal purpose for doing it? And if he did have a legitimate legal purpose, we can't do anything to you. So that's why it would survive that's why it would survive constitutional muster, is that we crafted this rule just as we craft any harassment or that does step onto First Amendment grounds. And it is
Years ago expressly declined to adopt the additional language in the ABA model rule. Is the board trying to get us to work that back in by court interpretation here?
the additional discussions with the ABA rule, there was a couple of issues, and ours is definitely more on that spectrum of constitutionality, more safe. And the reason is that it does have that constitutional safety valve, which the ABA rule did not. That's why Pennsylvania said that's a little bit too much, but in Colorado, they said it's just fine. I see that I'm out of time.
I do too. I wonder what
please,
Judge
Court.
Simpson would do if someone said that to him.
I think,
Mr. Allen.
Justice McDonald, I want to go back to one of your questions, where if it's just females in the office and they're making statements, we actually kind of have that in this case. And
But I bet you that Webster and Boyd were never, ever called limp dicks, ever.
I think that outlines what the problem is that the females in this office, and this was a female-dominated office, as we stipulated to, 9 of the 10 employees were all were females in this. So it was only Mr. Neff and another male were the only males in this office. And the females in this office were engaged in "that's what she said" jokes based on the Office television show. And then Mr. Neff joins in with it once after it had been consistently through the office, and now he's getting rung up. And in that world, I'm not saying that "that's what she said" can never be lead to the level of sexual harassment. I think anybody, that's what made The Office a fun show, was that anybody could look at that and say Michael Scott was in violation of Title VII when he was saying that throughout. But when he says it, Mr. Neff says it once in this context, he is not violating.
About blowing snow and his wife not objecting to it or liking it or something. So we know what the context is, that he said it. Do we know the context of when it was used by the other people in the office?
It's fair to assume that it would have to have that same sexual innuendo that's found. I mean, if we're assuming that it's along the lines of what was happening in the office, I think that's the purpose of that, and that's the natural extension of that. But as far as specifics, we don't have any of that. That's part of the stipulation.
Monica,
in any
thank you
event.
for the cheers. I forgot
Can you
about
respond to the
Twitch.
board's argument
Thank you.
that it's unfair, I think is what they're saying, to look at each of these specific statements in isolation? And if you combine them together, you would reach at least a sufficient level of pervasiveness that might avoid any constitutional problem.
I don't agree that if you do that. I think you do have to combine that. I think that that's fair, that you have to look at the totality of the circumstances. And it goes back to our prior discussion. It's got to reach to the level of pervasiveness. And the only reason you can make that determination is by looking at the totality of the circumstances to determine whether it's pervasive or not. But I think it's important to look at them first individually and then check that box that it's not any one of these comments
Violet.
individually do
Violet.
not satisfy that burden.
If they want to win their case, they better know that answer.
And then we look at it collectively. And I still don't believe that in this context, in this case, in the stipulations that happen here, it reaches that level.
About the gay slur incident. So as I understand, am I reading the stipulation correctly that your client used it in the context of relating a story that something secondhand? One of the individuals said she was offended, then your client used it again in the context of asserting his right to tell the story. Is that?
Really right. I think if I'm, and I know the situation, so I hope I'm not adding information that's not on the stipulation, because we're obviously bound by that. But the context of it was a person from the public called into the office and said that the prior county attorney was that gay slur. And Mr. Neff, relayed that story to one of the staff members. The staff member says, hey, you can't say that. And then his response is something to the lines of you're telling me I can't say that, or why can't I, or can I have the right to say that that county attorney is that gay slur. That one time, and then that's it. There's no other instances of any sort of sexual orientation discrimination that happened throughout this stipulation.
Find a violation, are we too late for a private admonition, since this is being live streamed and is on our public thing, record?
Attorney-client privilege discussions I had with my client, the reality is that this was very public as part of the employment discrimination hearing, and so we could have certainly requested the court make this confidential and use a doe name, but we decided not to add that extra effort in this case due to the prior publicity outside of this. But I still think a private admonition would be appropriate if that were the case. Thank you.
Concludes our morning session. You may adjourn court.
So here's what happened, guys. I did find out what happened. He actually was taken off suspension after this appeals and let back on the job. He got a public reprimand for those words, and he is still an attorney. Well, I don't know if he's an attorney right now. He could have got disbarred last week, but he did not get disbarred from this whole incident. So now I should have been prepared better. Josh liked, oh man, I cannot remember this judge's name for the life of me. I used to play this judge all of the time when I first started streaming. I used to send Law Talk with Mike, this judge, all of the time, because hardly anyone else did back then. No one watched this judge back then. I did. I loved him. I remember
Imagine being able to build an app with
this guy was in love with someone, and he was talking about just love throughout the whole case. It was great. I have to get it off of that and put it over here. Okay, let's get you guys in on the deal. I'm so sorry. It's hard to talk and not cough. I think this is it. Yep, that looks good. Now, sure. I think Josh said start at 50. $430. I love this judge. Can't remember his name. Okay. Before
Yes, sir.
I
Thank you,
press
Mr. King.
play,
Thank you, Judge.
there's two separate clips in here that we're going to see. But since we've only been streaming for 1 hour, we might just finish out his docket instead. We might just do this. So here we go. Martin, Judge Martin. Judge Martin. He gets really strict sometimes.
Okay. Well, I think
Ms.
you're doing
Tabram,
fine.
Ms. Tabram, has Mr. Schmidt already left?
No.
Sir,
Hey, do we need to bring Mr. Drennan over for it was just it's a writ hearing on bond, right? It's not a writ hearing on
It's
probable
Judge
cause,
Martin.
right?
And now
Judge,
I
I think
remember.
that
I sent Law Talk with Mike a clip about him. Gosh, 2 years ago, I bet it was. And it was a Harry Potter, something happened in the clip, Harry Potter. So Law Talk with Mike started calling him the Harry Potter judge. Do you remember that? Do you guys remember that? That was a while ago. I don't know if he still does. Yeah, Josh, we could just play more of Judge Cutie Pie. I can't remember his name either. We played him yesterday. I can't remember his name. It's fine. I don't need to know his name.
our writ hearing is gone from bond to probable cause, so I don't know that my writ was specifically filed for probable cause, but we're addressing that,
Okay.
and we've got.
Okay. I was just going to say if it was just bail, we could go ahead and do it there. But if it's probable cause, then bring him on over and we'll do it in person.
Brett Martin.
Yes, sir. Thank you.
You
Okay.
remembered.
All right. Thank
be
you.
there in a minute.
Brett Martin.
Thank you, ma'am.
Loud Elvis, I don't know. I didn't see that clip at all. So I don't know who the rapping judge is. But in 2023, Law Talk with Mike was calling this guy the Harry Potter judge. There's a super long pause in this. What do you mean, Josh? I'm in the middle of a live stream. You sent me this clip. It's not edited? The hell? I would never leave a long pause in my clips. I play professional clips here. Josh sent me this, guys. I am, like, OJ has got me super good at fast forwarding long pauses. Like it's my job. This is a long pause. Why did you tell me to start at 54? What, did I miss something? I was talking and I probably missed it. Here we go, guys. This is not going to take us to the end of this stream. So guess what? I am going to go back to Judge Cutie Pie to finish it out. Score. Win-win. Yay.
All right, court is on record in writ number WR 25-32, Wayne Drennan versus State of Texas. Mr. Schmidt, are you ready?
Yes, sir.
You're writ, you may proceed.
That's correct, Judge. I think that when we started this writ the last time, ultimately the writ was an agreed writ for personal bond. When I met with the state, Mr. Harlow and I discussed the contents of the arrest warrant affidavit. And both of us had agreed that the affidavit was appeared to be flawed. It appeared to lack probable cause or at least sufficient information to substantiate eyewitness identification of Mr. Drennan here. We proceeded with our writ and the court requested additional information. So today what we have done is we have had the alleged victim meet with law enforcement and conduct a photo lineup. And we're prepared to offer evidence to the court as to the results of that photo lineup identification and proceed.
Okay.
And I would allow the state to call its witness, unless state wants me to.
State can call. Your Honor, state calls Aaron McLeish.
All right. Do you know where you're going?
I believe so, Your Honor.
You're right.
You're going to
You
hell
know, you
if you
swear
don't
that the
change your
testimony you give
ways.
to the court today will be the truth, the whole truth, and nothing but the truth, so help you God. Steph, have a seat. You may.
Investigator McLeish, I'm handing you what's collective states written to. Before we begin, though, for the record, could I please have you state your name and spell your last name?
Yes, sir. It's Aaron McLeish. My last name is McLeaish.
And Investigator McLeish, how are you presently employed?
An investigator with the District Attorney's Office here in Van Zandt County.
And today I asked if you could perform a photo lineup regarding this case. Is that correct?
Yes, sir.
Are you qualified to conduct a photo lineup?
And Judge Hughes to witnesses' qualifications as a peace officer and her qualifications as far as investigative procedures, including photo lineups.
You accept the relation?
I do, Your Honor. Thank you. And Investigator McLeish, did you actually conduct a photo lineup with the alleged victim in this case?
Yes, sir, I did.
And can you tell me, as a result of that photo lineup,
Monica.
was the witness, Mr. Wiseman?
She has nice hair. And unfortunately, she put those glasses up there, so now I can't ask. But before she put the glasses up there, her hair was like back. It was like, it looked like she had a headband on without a headband. And I was wondering how in God's name she got her hair to do that. It was like, all right, without the headphones on, my hair goes down. Hers was like back like this, and then it just stayed there with nothing, no headband, no nothing. Now she has her glasses there, so hopefully she takes her glasses off again, because I would love to know how her hair does that specifically. It's confusing.
Been able to identify a photo of the person that attacked him.
He did identify a photograph.
And I've handed you states exhibit 2 collectively. I believe it's marked states A, 2A through 2M. Can you tell me what is 2A?
2A is actually the set of instructions that come from the Texas Department of Public Safety regarding the photo lineup and the administering of such, as well as the instructions that an investigator is supposed to read to a prospective witness.
And 2B through M, are those the actual photos that Mr. Wiseman inspected?
They are, yes, sir.
And did you get the full name of the victim in this case?
Timothy Sizemore, yes, sir.
Sizemore or Wiseman?
I'm sorry, Weissman. Yes, sir.
And where did you meet with Mr. Wiseman?
In the witness room here at the courthouse.
Okay. And about what time?
About 1:30 this afternoon.
Okay. And for the record, today is October 2nd, 2025. So Mr. Wiseman did in fact make an identification in those photographs?
He did, yes, sir.
Can you tell me of states 2B through 2M, which of those photographs he identified?
Ultimately, he identified Exhibit 2B as the person that was at the scene.
Did he identify any of the other photographs?
He did, yes, sir.
Can you tell the court which other photograph?
That would be 2C.
And can you go ahead and remove the photograph from 2B?
From 2B? 2B? Yes, please.
Yes, please.
Yes, sir.
Yes, please. 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 Yes And for the record, the person arrested in this case, Mr. Drennan, can you identify where he's seated in the courthouse?
I can, yes, sir. He's to my left wearing the orange top.
And Your Honor, may the record reflect that this witness has identified Mr. Drennan?
Record will reflect that this witness has identified the individual Dwayne Drennan here in open court.
And Investigator McLeish, is the photograph contained in 2B a photograph of Mr. Drennan?
Not in my opinion, it is not, no, sir.
And can you pull the photograph from Exhibit 2C, please? And is that photograph a photograph of Mr. Drennan?
No, sir, it is not.
How confident would you be in saying that those are that those two individuals in the photographs are not Mr. Drennan?
I'm 100% confident that these are not this gentleman here in the courtroom.
And those are, in fact, the individuals that Mr. Wiseman indicated to you attacked him in this case?
That is correct, sir.
And to be clear, Investigator McLeish, there weren't two people who attacked him. It was one individual who attacked him.
I'm sorry, Mr. Hartwell, I'm not familiar with any of the details of the case.
And your unfamiliarity with the case, is that one of the reasons why you were asked to conduct the photo lineup?
That is my understanding, yes, sir.
State passes the witness, Your Honor.
No question.
Board has a couple of questions. Investigator McLeish, can you tell me about Mr. Wiseman? Did he wear glasses, contacts? What is his age? Did he appear to be in any kind of state of concern during the photo lineup? Is there anything that this individual in his behavior or the way that he viewed the lineup would give you cause for concern as to his competency or anything of that nature?
Yes, Your Honor. I did not see him wearing glasses. I did not ask him if he wore contacts. He did not express any concerns to me about this process. However, initially at our introduction, he did explain that he has recently suffered a heat stroke, which at the very least has incapacitated his communication to a degree. I asked him before I administered this lineup if the effects of the heat stroke would impair his ability to make an identification, and he told me no. However, at the end of the process, he had to sign a document. And so I asked him to please remove the document, and I showed him on the document where I wanted his signature, and I even marked it with an X. And he took a considerable amount of time before signing it, scrutinizing my location, and then he made the comment that since his heat stroke, he had a difficult time seeing. And of course, we're in here asking him to look at photographs to make an identification. So I repeated my question to him. I said, you're having a hard time seeing. Are you able to make this identification? He did answer affirmatively, confidently affirmatively. He said, yes, I can do this. But it did leave me with some doubt that he was having a hard time seeing a blank that I just indicated to him for his signature.
You're in jail?
And let me ask, I don't think it was asked before, was the defendant's photograph actually contained in the lineup that you presented, or was the defendant's photograph not contained in that lineup?
Your Honor, I do not know the answer to that. I haven't looked at any of these photographs except for the two that I was just questioned about.
Your Honor, I can't answer that. I believe it is.
Did you see the judge's face on that question? Oh, he's not happy. He is unhappy about what's going on right now. Somebody, I think, is in trouble. Oof. Oh, press play, press play.
2D, I believe, is, if Investigator McLeish would like to open up 2D and make sure that it is.
That was the gentleman in the courtroom.
Okay. Is there anything else, Investigator McLeish, that you think would be important for the court to know regarding the, and I'm assuming that the way that the photo lineup was presented was a double blind, or was it a single blind? It wasn't a 6-pack.
Correct, Your Honor. It was a 12-pack. Investigator Crawford put the photo lineup together. Investigator McLeish had no part in putting the photo lineup together. That's why we had her administer it.
So there were 12 photographs on one sheet of paper.
No, Your Honor. I'm sorry, 12 individual
So it
photographs.
was a line,
Yes, sir.
Sequential.
sequential,
Yes, sir.
not a pad.
Correct.
Okay. All right. Anything else from
Both
the
of our
state?
minds went to the same place, Josh.
Uh,
It had nothing to
Not
do
at
with
this time, Your Honor.
alcohol.
Anything else from the defense?
Not from this witness, Judge.
Thank you, investigator.
Thank you, Your Honor.
Your Honor, I apologize. State does offer states to collective, or states writ to collectively.
No objection.
All right, there being no objection, states 2 is admitted.
Thank you.
Mr. Schmidt, I think it's still your writ, and you defer to them to call a witness. Do you want to call any witnesses at this time?
Judge, I have witnesses that I can call to bolster the testimony that you just heard. If the court requires that, then I can. Otherwise, the sake of expediency, I believe that I've conferred with the state and they intend to make an oral motion to reject the charges against him. And if that's still the case, then we'd ask to proceed that way. I know that we started out rewritten on PR bond, but obviously it's our contention that it is a misidentification of Mr. Drennan, and we would much prefer the charges be rejected than him out on bond.
Yeah.
So
Set
if
him
the
free.
state
Let him
still
go.
intends to do that, then we would ask that they make that motion, and then we would call any additional witnesses.
State.
Yes, Your Honor. State does intend to reject the charges at this time. I think at the point that we're at with the evidence that's been gathered today, more investigation is needed in this case.
You mean more investigation is in
All right, very
find
well.
the real
Then
criminal?
the court finding that the state has indicated to the court that it is rejecting the prosecution
No.
of the charges. The
Josh.
court hereby.
We never get to see this happen, Josh. Usually, if it's misidentification, and the judge is just like, don't worry, it'll come out in court. I understand you have a defense, but now is not the time to talk about it. Instead, they're letting him go. They're not a bond. He doesn't get a bond. He's just being free. Josh, that's a rare rarity. You just gave us a rarity. Oh, shit.
Releases Mr. Drennan from custody. Is he being held on any other charges?
He's got a hold from Dallas County Judge, but I believe that the only one, yes, sir.
All right, then the court will sign an order releasing Mr. Drennan on this charge. And state, can you provide me with a notice of rejection?
Yes.
Or a declination letter so that I can attach it to my order so that the sheriff's office is clear?
Yes, Your Honor. I'll work on printing that up before I leave today.
Okay. All right. If there's nothing further, then as soon as I get that, then I will go ahead and draft the order and get that sent today, Mr. Schmidt.
Thanks, sir.
Right. I believe that then concludes the court's afternoon docket. The court is adjourned.
Okay.
Say it.
Sorry. I'm sorry. I'm hoping Oh! Guys, guess what? We are already set up from yesterday. I think we're right where we stopped yesterday. I think I could just press play and move on with my stream like a professional. This is what professional lives feel like. This is nice. Hi, Judge Cutie Pie. I'm not gonna go sit beside him today. Oops, I missed. Yesterday I sat beside him. I'm gonna be up here with Justin. Hey, Justin. Hi, Busty. All right. That's the wrong button. hope he smiles today. I just hope he smiles. One time. One time.
Judge, I'm ready to call Latoya Jones.
Thank you.
Morning Glory incense today is not my favorite. And this is
Morning, Ms.
the
Jones.
first one from the pack, so I have to get through this whole pack.
We're calling two cases,
Not my
25
favorite.
CR 1468 and 25 CR 1050, People versus Jones. I'll take entries, starting with the people.
Aaron Brunskill for the people.
Tempest Cantrell on Ms. Jones's behalf. She's in custody to my left.
Thank you. These matters come on for sentencing. Ms. Cantrell, you ready to proceed?
No, Judge, we're not ready to proceed. We're asking to continue the sentencing
Me
for 3
first.
weeks today.
Me
I have
first.
ordered some records
Arrest
that I
me,
think that
please.
are very important that I want to provide to the court in advance of sentencing. And I talked with Ms. Jones about that request, and she wants to also.
Josh, remember this while you're there, please. If you're going to go to Colorado to get arrested so that you get in front of Brett Martin, do not use the 2 words that we heard in the first clip. Don't call the judge that, please. Don't. No, don't. If I get arrested, for the love of God, do not bail me out. Please, leave me there. I'm enjoying myself, really I am.
So continue the sentencing to be able to get those records.
Thank you. Mr. Brunskill, your position?
I'm not objecting to a continuance. The victim in the 25 CR 1050 case, Mr. Burris, Ms. Jones' husband, is present in court. I discussed continuing this with him. He supports the continuance because he agrees with the reasoning. Defense counsel is seeking these records. So
Okay.
no objections.
Okay. Thank you, Mr. Brunskill. And I'm sorry, Ms. Cantrell, did you say you need just a couple more weeks?
3 weeks,
3
please.
weeks. Okay. I do find good cause to continue the sentencing so the court can have all appropriate information. We'll find a date in 3 to 4 weeks. I don't know how we're looking on the 21st. Okay. I think I'd rather say on the 21st than the 28th. So, yeah. So.
Okay, we could do it.
Okay. How is Tuesday, October 21st at 8:30?
1 second, let me confirm. I can accept that.
The people can accept that, and Mr. Burris said he can as well.
Okay, great. Thank you, folks. We'll be back then on October 21st at 8:30 for continued sentencing. Thank you, everyone.
Thank you, Judge.
Thank you.
Same.
I was talking. I'm sorry. I was here. I was chatting in a chat and didn't realize the quiet that crept over the courtroom.
Body-worn camera for Ms. Losa's co-defendant. We recently received the proper body-worn camera, but Ms. Losa just needs more time to actually review that, so we are asking to set over.
Thank you. Mr. Freeman, your position?
Yes, Your Honor, I've spoken to the defense. This is the first arraignment. I don't have any objections to that request.
Okay, thank you.
And then a Tuesday, please, for Mr. Freeman and I.
Okay.
Okay, thank you. I do find good cause to
Stop.
continue the matter
Brett,
for further arraignment.
Brett, love, when I speak, you be quiet, okay? I have an idea. Guys. This idea cannot fail. This is the greatest idea I've ever had. Okay? All right. Let's have a get together. Let's all meet in person. Oh, what? You think you can't afford it? You know, you can't afford going somewhere for a week and paying for food and paying for lodging. You don't have to pay a dime. You don't. You'll be fine. And we'll be fine if enough of us go. This is what we're going to do. We are going to go to a city that we choose, any city. Pick a city, all right? Or we could go to, like, the poorest person in the chat. We'll go to that city. That way they don't have to travel. And then we will all commit a crime small enough to land us in jail for a week. And if there's enough of us, we'll be our own little gang. So no one will mess with us. And we'll have a whole week to spend together for free. Free food, free lodging, in our own gang, running the show. Wow, CJ just threw out Sydney, Australia. That would definitely handicap a lot of us. We would have to get passports and then money. Oh gosh. And then that plane ride would suck. But oh no, Linus, don't get kicked out of the country. Yeah, Violet, don't question it, Violet. Just go with it. Just let it happen. We're gonna have the best time, and then we can all write a book about how we had the best time of our lives in jail. And it'll be a bestseller. I love this. Somebody pick a city that's not international, please, because I don't know where my passport is. I can't find it.
We'll find a Tuesday on the G docket. I don't know what the typical set it over is, but
He usually does 4 weeks.
Okay.
How is October 28th, 8:30?
Works for the people.
That works for defense.
thank you. Bond will continue to October 28th at 8:30 in Division G. Anything else from either party?
Nothing further from defense.
Not from the people.
Okay, thank you, folks.
Thank you.
It would actually be the best time because
I'm ready on Mr. Reed. I have.
jail only sucks because the people in jail make it suck. If the people in jail were nice to each other, jail would not suck. It just wouldn't. It would just be a place that you're living in for a while. If they would just be nice to each other, they could be fine. We would be fine together. We would have a good time. We would sit around and tell stories. We wouldn't be able to get toilet hooch. Toilet hooch. We would have toilet hooch. Do not worry. I will make the hooch. I got this.
I'm bringing him out.
Thank you. Morning, Mr. Reed.
Morning.
This is 25 CR 1719, People versus Reed. I'll take entries starting with the people.
Eleanor Lansbom for the people. And Carrie Coble on behalf of Mr. Reed, who appears in person in custody.
Thank you. This matter comes on for arraignment. Ms. Coble, how would you like to proceed?
Thank you, Your Honor. Mr. Reed would like to plead not guilty and set this matter for motions, hearing, and jury trial today. And then we are also asking to address bond.
Thank you. Are the people very compliant to address bond?
Your Honor, if I can have just 1 second.
Sure.
Your Honor, I'm not seeing that the people were on notice that defense would be asking to address bond today. I am not very compliant.
My recollection is that at the last court date, we did say that we'd want to address bond at the arraignment. Because I know we purposefully didn't address it at the last court date as well.
I don't say that in minute words. I'm not doubting your recollection there, Ms. Coble. But given that we are not BRA compliant, I find that we cannot address bond today. It looks like bond was addressed September 10th. So I don't find any significant prejudice in continuing the issue of bond. So first we will, I'll accept the not guilty plea on behalf of Mr. Reed. For the record, speedy trial will run March 30th, absent any tolling or waivers. We'll set the matter for trial and then set the matter for hearing concerning bond. Are we seeing this as a Monday or Wednesday setting?
Your Honor, I think this is probably a Wednesday.
I agree.
Okay, thank you.
Nan don't want no man paying for her drinks, Josh. No, she don't need no man's help. I have to see what this is real quick. It's killing me. Oh, hi, Christopher. It's your belly.
How is Wednesday, February 4th at 9 a.m.?
That works for defense. There will be dates sooner than that.
I can accept that.
Okay, thank you. Matter will be set for jury trial beginning Wednesday, February 4th at 9 a.m. And then for pretrial conference.
How's Tuesday, January 27th at 8:30?
That also works for defense.
I can accept that.
Thank you. Pretrial will be Tuesday, I'm sorry, we say Tuesday, January 27th. Right. January 27th at 8:30.
Oh, I just wish a Karen or a Sofsit would come in front of him.
Motions, how
He's
is
too chill.
Friday, December 19th at 9 a.m.?
I can accept that.
I can do 9 a.m., yes.
Okay, thank you. Motions will be Friday, December 19th at 9 a.m.
Is that a white tie with a white shirt, though? Is that what he's wearing?
Ms. Lansbaum, would it be realistic to set the matter over this Thursday for a bond hearing, or would you request a further setting?
If we could have next week, please.
Okay. We'll need to have the matter covered, but we can set the matter Tuesday, October 7th at 8:30. Does that work for both parties?
Yes.
Yes.
Okay, thank you. Matter will be continued to Tuesday, October 7th at 8:30 for hearing concerning bond. We'll order the people to make good faith efforts to be BRA compliant to address bond at that date. Ms. Coble, anything further?
No, Your Honor, thank you.
Thank you. Ms. Lansbaum, anything further?
Thank you.
Okay. All right. Thank you, Mr. Reed. We'll see you next week, sir. Thank you.
I'm just
And then
waiting
I'm
for
ready
a
on Miss
smile.
McClellan.
Please.
Thank you.
Judge, please.
One moment. And do we have Ms. McClellan?
Yes, she's in there. The
Okay,
deputy
great.
should be bringing her
Great.
out.
Morning, Ms. McClellan. I'm doing well, thank you.
That doesn't
This
count.
is
I need a
24
smile,
CR
not a fake smile.
2189, People versus McClellan. I'll take entries starting with the people.
Josh Rhines for the people.
And Carrie Coble on behalf of Miss McClellan, who appears in person in custody.
Thank you. And Ms. Casillas, are you appearing on this case as well?
Yes, Judge.
Okay, good morning.
Good morning.
This matter comes on for review. I did receive notice, looks like there is a bed available for Ms. McClellan on October 2nd. That would require a PR bond. Ms. Coble, how are you asking to proceed?
Yes, Your Honor. We are asking the court to grant a personal recognizance bond. I have discussed that with her public defender in Jefferson County, as well as the CDHS liaison, that she does have that place. And she was granted a PR bond in the Jefferson County case so that she can go there. Releasable to Bridges and Druid ride services is what they put as the condition of bond in the other case. So I would ask that the court grant her a PR bond so she can do that.
Okay, and you say it was at Druid?
Yeah, Druid Ride Services, I presume that's who does the picking up for the place. Yeah.
Thank you. Mr. Rhines, your position, sir?
The people are VRA compliant regarding this bond request. The people don't object given the terms proposed. Further, the name victim Roy, he defers to my position on that one, so there's no objection there. Yeah.
Okay, thank you. And Ms. Casillas, anything further on that or any other conditions we need to make sure are on the bond?
So Druid was supposed to be doing the transportation. Unfortunately, they are not able to do that transportation. But I do have another program, Service of People. They will be meeting me there at the jail to provide transportation to the mental health transitional living home.
Okay, so if the bond is worded releasable to Bridges program staff only, we will have a member of Bridges to.
I fully intend on trying my hardest to go see Judge Fleischer when Eileen goes in 2006. So that might be a good idea. We can meet up in Harris County, Texas, Houston, in 2026, which is coming really freaking fast. So start saving your pennies now.
Facilitate that irrespective of the ride service?
Yes, yes.
Okay. Thank you. I have reviewed the recent report noting the bed space available. I do find good cause to grant a.
I'm going to be drinking alcohol during this trip. Just telling you that right now. If that's not something you want to do, then you can find me later at the bar. That's awesome. So we don't have Zoom here, Sherry, but we do have Discord. And after the streams, we used to get into Discord all the time and talk to each other. Some of the mean people would bully everybody into putting their putting their camera on, but you don't need a camera. You guys can go into Vocal Vibrations. It's in there. It's in Discord, and talk to each other anytime. There was times when that was open 24/7. People were just in there talking to each other. So it's there. You can play games with each other. You can do whatever you want in there. It's your Discord.
$20,000 personal recognizance bond for Ms. McClellan to reside at the MHTL program. So that bond will be releasable only to Bridges program staff starting October 2nd.
That's new? Guys, that's new. MHTL program? So I know Bridges. They talk about Bridges all of the time. It's one of their excellent programs they have in Colorado. It's not as good as Rise in Indiana, but it's good. But what is this MHTL program? I hope he explains it.
Condition of bond will be complying with the MHTL program and any restoration services. We'll also modify the court's orders and change the restoration orders to outpatient restoration.
Shit, I need
And
to
I
get a
think,
link for
given
Violet.
that, it sounds
I'm
like we'll
gonna
be on
get
a
you a
new
link.
91
One
day
second.
term. So I think we'll have to set the matter over 91 days. Anybody disagree with me on that
No, Your
timeline?
Honor. The only thing on that I would say is, I think the court had a previous outstanding order for a new evaluation, or at least report on restoration to be filed, and it doesn't look like that's been done.
Okay, thank you, Mr. Rance. Thank you. So there will be the court's orders as to the bond. We'll find a date in roughly 91 days or shortly thereafter. Anything else from either party apart from getting the review date?
Not from defense, thank you.
No, thank you, Your Honor.
Okay, thank you.
Yeah, but what is it?
30th.
Is it a housing with a whole bunch of
Tuesday,
others?
December 30th.
Is it your own apartment? Do a
That works
couple
for
of you get an
defense.
apartment together? Do you see a counselor once a
That
week,
works for the
once a
people.
day? Do they make
Thank
sure
you.
you take
Ms.
your
Casillas, does that
meds?
work for you?
What is it?
Yes.
Okay, thank you. Matter will continue then to Tuesday, December 30th at 8:30 for review. Okay, thank you, folks. Thank you, Ms. McClellan. I know it's been a long wait for that. I'm glad we
Violet,
found
there's
space
the
for it.
link to Discord.
Thank you guys for giving me a second chance. And I'm excited to go to this program. So.
Good. I'm glad to hear it. Thank you for your patience. We'll see you back in December.
Not a real
thank you.
smile. Not a real smile.
And then I'm ready on Miss Musari.
Morning, Ms. Musari.
Ginger.
This is 20 CR 1790, People versus Musari. I'll take entries starting with the people.
Your Honor, may I have a moment?
Yes.
Josh Rhines for the people.
Thank you.
And Carrie Coble on behalf of Miss Musari, who does appear in person on bond.
Thank you. This matter comes on for setting. Ms. Copel, how would you like to proceed?
Thank you, Your Honor. We are asking to continue the setting. Ms. Musari has ordered her medical records. From my understanding from notes that were had with a discussion with Ms. Shelton, I
just
believe it
click it.
was. But I do believe there is,
think you're
if we can
fine.
provide the medical documentation, they're willing to withdraw the complaint. So that's my request. Thank you.
Thank you. Mr. Rance?
The people would just ask that we reset this on a Tuesday or Wednesday.
Okay, thank you. I do find good cause to continue the matter for a further setting. We'll find a Tuesday.
Oh, please do, Josh, please.
And I think we're okay to look into
Please,
November,
Josh, please.
given our docket. Yeah.
How's Tuesday, November 18th at 8:30?
That should be fine for us.
That works for defense.
Okay, thank you. Bond will continue to Tuesday, November 18th at 8:30. Ms. Colby, anything further?
No, Your Honor. Thank you.
Thank you. Mr. Rance, anything else?
No, thank you, Your Honor.
Okay, thank you, folks. We'll see you back then, Ms. Missouri. Thank you.
I'm the professor.
And then I'm ready on Mr. Doyle Regador.
Thank you. Good morning, sir. This is 25 CR 1859. And how do you pronounce your name, sir?
Doyle Rigador?
Okay, Doyle Regador.
It's like-
I'll take entries starting.
I know this guy's not going to be interesting. I know before they even get up to the podium whether they're going to be, whether they have a chance of being interesting or not interesting. Come on, Josh. Not Josh, Brett. Bring some prisoners out.
With people. Aaron Brunskill for the
Josh,
people.
Brett, same
And
people.
Carrie Coble on behalf of
Same.
Mr. Doyle Regador, who appears in person on bond.
Thank you. This matter comes on for arraignments. Ms. Coble, how would you like to proceed?
Thank you, Your Honor. I am just asking to set this over for a second arraignment. I just need some more time to go over discovery and discuss the offer with Mr. Regador, or Doyle Regador.
Thank you. Mr. Brunskill?
No objection.
Okay, thank you. I do find good cause to continue the matter, noting Ms. Coble's appearance or entry of appearance just on the 10th. We'll find a date for a further arraignment.
How's that November 18th date?
That works for me as well.
That's fine.
Okay, thank you. Bond will continue to November 18th at 8:30. Anything else from either party?
Not from defense.
No, thank you.
Okay, thank you, folks.
And then I'm ready on Mr. Payan Rodriguez.
Thank you. Morning, sir.
How are you?
I'm doing well, thanks. This is 21 CR 3450,
I
People
need more,
versus Payan
CJ. I
Rodriguez.
can't remember
I'll take
that.
entries starting with the people.
Agador.
Aaron
Agador.
Brunskill for the people.
And Carrie Coble on behalf of Mr. Payan Rodriguez, who appears in person on bond.
Thank you. This matter comes on for sentencing. Ms. Colbert, are you ready to
Okay.
proceed?
Sentencing.
No,
Let's
Your
go.
Honor, I am asking to continue.
Darn it.
Mr. Payan Rodriguez does have a new matter that's set for preliminary hearing downstairs. Our plan is to waive that preliminary hearing and have that set for an arraignment. But I would ask to continue this sentencing
I
to
am
continue working
52.
out a global disposition.
Thank you. Mr. Brunskill?
I don't have an objection to that.
Okay, thank you. Noting no objection, we'll continue the matter. How far are you anticipating for the arraignment on the other case?
I would just, if we could maybe set to that November 18th date as well, I can accept that.
Okay, Mr. Brunskill, any objection there?
No.
Okay, thank you. We'll continue the matter to Tuesday, November 18th at 8:30 for further sentencing. We'll see where things stand with the 25 CR matter. Obviously, if that matter is going to be separate trial, we won't trail the sentencing indefinitely. Anything else from either party?
Not from defense, thank you.
Mr. Brunskill, anything else, sir?
No. No, thank you.
Okay, all right, thank you. Bond will continue to that date. We'll see you back then, sir. Thank you.
It's November 18th. And then I'm ready on Mr. Romero.
I'm going to have to look at it, CJ, because I can't remember.
Thank you.
And I know
Dominic
them
Romero.
all.
Mitch, okay.
I've
Morning,
watched
sir.
them all a million times, and I cannot
This
remember
is
that.
23
That'll
CR
kill me.
900. I'll take entries starting with the people.
Aaron Brunskill for the people.
And Carrie Coble on behalf of Mr. Romero, who appears in person on bond.
Thank you. This matter comes on for setting. Ms. Coble, how would you like to proceed?
Thank you, Your Honor. I am asking to set this over for another setting. Mr. Romero does have the new law violation that is set for trial fairly soon. So I'm asking just to set over until after that. So if we want to set out till the end of November as well, that'd be my request.
Big
And when is it
statue.
set?
Not,
I'm just
not
double-checking the
hand.
exact date.
Big statue, right? I'm getting there. I'm getting there.
It is
I'm getting there.
November 25th. So actually, if we want to set after
CJ,
that.
was that the one
Okay,
with the...
Mr. Brunskill?
I'm not objecting to a continuance today, but I
Stop continuing everything. Knock it off. Get something done. CJ, that was the one with the new companion, like she's the flower girl out front of it. She puts flowers, and then later on she becomes a companion. Is that the one? Is that what we're talking about? All right. I'm going to go fast forward a little bit to see if we can't get something that's not a continuance. Sugar. We're just going to go from here. The stream's almost over. Let's see if we can get something. Yes.
Yes.
Okay.
That is the one. CJ.
This is 25
Oh.
CR 679, People versus Munger. I'll take entries starting with the people.
Julia Brady for the people.
Morning.
I'm Leah Fleischman on behalf of Mr. Munger. Mr. Munger appears via WebEx, and I appear in person.
Oh, I got
Thank you.
Christopher.
This matter comes on for arraignments. I believe there was a virtual writ issued, but it looks like Mr. Munger is on bond. Ms. Fleischman, any further record as to the virtual appearance?
Judge, she's actually in ComCore.
Okay, thank you. Thank you. This matter comes on for arraignment. How would you like to proceed?
Judge, I have uploaded paperwork into the court file if the court is willing to take the plea agreement today. Mr. Munger is going to be pleading guilty to added counts 4, which is driving under the influence, a third or subsequent offense, and count number 5, which is possession of a controlled substance, a drug misdemeanor 1. We are recommending sentences to be run concurrently with Mr. Munger's current ComCore sentence, and we are hoping to do sentencing today.
Okay, thank you. And I don't see the paperwork yet, Ms. Fleischman. Can you double check that it went through? And Ms. Brady, any objection to proceeding with plea this morning via WebEx and immediate sentencing?
I have no objection to all that.
Thank you.
I didn't hit the final button, Judge.
Gotcha. Not seeing it yet. Let me know when it goes through.
Jude, this is general, okay? This is general. Yes, I missed some text messages because I was sleeping. This is what you normally see. Yeah, it was CJ. That's the one where they met the new companion, right? The girl was the flower. She was taking care of the flowers. Is that the one? No. All right, Jude, are you watching? These are all the text channels. If we skip all the text channels and go down, right here are voice channels. I remember Office Centurion.
Thank you.
All right, Brett, please be quiet, Brett. So these are the voice channels, okay? If you want to play games with other people, you can talk to them like I do, or you can go into here. If you want to talk
Okay, thank you, Ms.
them.
Fleshman. I have it now. Mr. Munger, I'm going to go through the plea paperwork with you, sir.
No, you're not.
At any point.
If you want to talk to them with your headset. Well, now you're in general. I would go into vocal vibrations, but there's no one else in there right now. But that's where you can talk to other people in vocal vibrations. I'm connected, but I have to hang up because I'm a little busy right now, just a little bit. So I just clicked it to connect. Now to hang up, I'm just gonna press this disconnect button. Now, general is where you can talk to anybody at any time. And you can, what in the, you can do that. And you can do it 1,000 times. If you just want to tell a story about your life that you think people will be interested in, there's one. There's a place where you can just tell us stories about your life so that we know you a little better. If you're having issues and you're scared, you want to talk about the issues, but you think you're going to bother people, whine away. You can put anything in there at any time. If you want to talk to someone, you have an issue, you can take it to the whine away. Memes. If you want to post inappropriate memes, this is a great place to post. But if you do giggle at one, be nice. Hit. It doesn't matter what you hit. Hit them all. What if what about it? Give them a trophy. Okay? If you want to talk about food. Yum. Those are slices. That's a slice. Now we know. But there's lots of food in here. If you want to talk about your hobbies, right here is where you go to talk about your hobbies. And you can see, I'm hoping it's close. CJ's stuff. Nice. Terry, you go, girl. But Linus loves her plants, and so does Jen. Jen is that was mine. Don't worry about that one. Just don't you worry about that one. Don't look at it. Just close your eyes. That's her paintings. That's freaking wicked cool. Wicked cool. Gardens, lawns, crochet, all kinds of stuff. If you want to do music, here's where you post the music that you want to listen to or you want everybody else to listen to. You can just pause it and rewind it when you want to know. This is recorded. You know this tab because you have been placing videos here. We love our military. You also know that tab because look at you go. Look at you go. Animals. Aminals. Lots of aminals. All aminals. All the time. I think it's way up. Look at you. This tab will get you. This tab will keep you locked in for a long time. Oh, I can't. Oh, you know this. You already know this tab. Weather. If you wanna, the leaves are turning, so we all should be. Come on. Is this so you don't fall off the frickin' ladder? No. Someone explain that to me. I don't know what that is. I don't know what they are. Should I have read more? Should I read before I ask? Josh is telling me you should read. Oh, it's from the Netherlands. That's why I have no idea. And she's gone. Oh no, she's here. What is that? What are they? Anyway. If you're replay crew and you want to talk to people, there's replay crew. And that pretty much covers it. Just down here. You're still love, Jude. When you get in here and you want to hang up because there's no one else in here, you just press this little button right here. Just hang up. Just hang up. Or if you sit in there and wait, other people will come. That's how I used to get people. I used to just go into vocal vibrations. I used to just click it and wait, like fishing, and people would come. Okay. I would like to get rid of that now. And I got rid of the wrong thing because I'm an idiot. Alright guys, we made it. I'm going to go do OJ. Everybody wants to hear you babble. Everybody. That's what we want. I'm going to set up OJ. Thank you so much for coming out, guys. I really appreciate it. I do. Sorry I was late. I don't work today, so I have plenty of time to rest. Tomorrow I won't be late. Nice, Violet. Nice. I'm about to start another stream. So I won't be able to get in Discord, but you guys can get in there 24/7. Bye, guys. Have a great day. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.